All right, guys, welcome to the Daily Justice Stream. Justice is a process here, and we are going to be jumping back into the state of Florida versus Franklin Tyrone Tucker. And we're going to be watching the morning session. So it's already started. It's on break. It'll be on break till about 1 o'clock, but fireworks already starting. Things we need to watch already starting. The judge is already starting to try to keep important evidence out that would help Mr. Tucker because, again, I kind of took a little preview of it. And what you're going to see, what we're going to see is a very, very important witness, a witness that the state does not want to call. This is one of the primary surviving victims who had a neck injury, whom does not name Mr. Tucker as an assailant, who the state should obviously want to hear from. I mean, she was there at the scene. They're wanting to keep her out of court. She's very, very sick. Her doctors have said it's very important that they take her testimony if they want to get her live testimony on record. And the judge is stepping in between that, one of many other things. And then, of course, there's an issue as Detective Malone's testimony is going to continue later this afternoon. There's impeachment materials that the judge is trying to keep out. Anyways, lots of stuff. So let's jump in, guys. I'm going to try to jump around here and get caught up. It starts out first with Mr. Tucker. He's running a little late because he's been over at the medical center trying to talk to the physicians that are responsible for Paula Belmont's medical treatment. So we'll jump in there and take a look at that. So let's take a look here.
The 16th Circuit of the State of Florida is now in session. The Honorable Mark H. Jones, Judge presiding.
Good morning.
Morning.
Be seated. State versus Franklin Tucker. I see the prosecutors are here, but the defendant is not. My assistant said that he called about 3 minutes ago and says that he's at Lower Keys Medical Center attempting to get the medical information about Miss Belmonte and is en route. So this is troubling. It's an issue that I addressed with the defendant last time he was late. So, not much I can do at this point, other than, did you all receive the materials that you were...
Judge, we received a generalized list Saturday morning that did not narrow down. I think he listed, am I mistaken, David, like a 2-hour portion of the IA interview that he said he intends to use for impeachment. Again, no specific area of the interview other than, I think it was a 1 or 2 hour block.
That is correct. And also on the 12th of, I want to say of this month while we were in trial, he filed, I guess, some supplemental discovery that he intends to seek to use during his, I don't know what part of his case. I found out about it yesterday because I just happened to check the clerk's website. So I did file a motion to exclude that based on relevance. So I filed that motion this morning, but I do have a hard copy for the court.
Okay, well, we will address these things when Mr. Tucker appears.
Very well.
Would you, bailiffs, let me know when he arrives?
Yes, sir.
Thank you. 16 CF 841. So, Mr. Tucker, you're 3 minutes late. What's going on?
Your Honor, I actually did call the court. I was at the hospital with Miss Bellamont. I filed an emergency motion because Ms. may not be here to testify on Thursday. She may not be, not only not able, may not be able at all. I was there waiting for the primary physician. I called your office with about a half hour left before court. I could have made it here in time, left my number just so that I could get the advice from the court. But I tried to get...
I'm not so sure why that couldn't have been done over the 3-day weekend.
Because the primary care physician wasn't there, Your Honor. I have no say in his scheduling. But I did go in this morning. He actually, last I checked, he was writing it after I left because he was with a patient. That's what I was waiting for. But he went ahead and wrote the letter that you required. And I also asked that he leave a contact so that Your Honor could go ahead and contact him directly. But her situation has apparently gotten critical. She may not be here till Thursday. Be here on Thursday or Friday when she would be potentially testifying. If Your Honor would look at the motion, it's explained in there.
Well, okay, that's not my first priority. I'm not sure what motion you're referring to. Well, what is the nature of the motion? What relief are you asking for?
Your Honor, that's exactly what I was just explaining. She's critical. She may not live till
You
Thursday.
explained her condition, but you didn't explain the relief that you're...
No, the relief's in the motion, Your Honor. But what it is really all I'm trying to do is accelerate the Zoom hearing that we had talked about and be able to hold it immediately today as opposed to putting it off till Thursday or Friday.
Yeah, I'm not going to address that right now. We'll get to it. Right now, I'm going to address what I said I was, and that is the discovery or the impeachment material.
Yes, sir.
So, did you get the state the impeachment material that you were intending to use in order to provide?
Yes, sir.
Okay. So, State, have you received materials from the defendant?
Judge, we have the materials. Again, my objection is the defendant said any or all of this 2-hour-long IA interview. And again, I'm asking for what portion, what's the inconsistency he's going to impeach, and what portion of that interview is he going to use to impeach it?
Okay. So, Mr. Tucker?
Your Honor, it's impossible for me to say exactly everything I'm going to try and impeach when I haven't finished with my questioning yet. There's no way I could tell him that. If she doesn't say something inconsistent, then I can't use it. It's that simple. I can't exactly say all I'm going to use, but I did limit myself, which I don't think I had to, but I limited myself to those things that I gave to the state.
Well, it's most extraordinary that someone would think that out of a couple hour, or however long it is, tape, that it would be virtually all potential impeachment. Attorneys are expected to be able to provide the opposite side with as specific a notice as possible of what they intend to use or believe is impeachment. So,
I did do that, Your Honor. I just didn't point to specifics in each testimony, which I don't think the state's going to do either.
So, how would you gentlemen like to proceed? I remember speaking on Friday that you almost anticipated that I would have to view the entire thing. And so that's one of the reasons we're here and put the jurors off until 1 o'clock.
Yes, sir. Judge, let me just apprise the court. The defendant emailed us Saturday morning at noon, which was the deadline, and he said, I plan on using as follows: interview room tapes 1 and 2, IA tape multiple sections, And again, I would ask, we're not going to sit and play a 2-hour IA tape, so I would just ask for what's the inconsistency and what portion of the IA tape. I mean, our witness is coming back in today. We're in the middle of cross-examination. We're going to pick up with where? Where do we start? Is he going to try to impeach her right off the bat? Is he going to begin questioning her? Is there already something he feels that he has the right to impeach her on? I'm just not clear where we pick up from today.
Yeah, I mean, Mr. Tucker,
Your Honor.
when the witness is coming, you have to be able to cue this up and present it. We're not going to have what
Exactly.
we had on Friday. We're not going to, that's
No, I understand, Your Honor.
people back and forth and waiting anymore. So you have to be able to identify what it is you intend to use.
Your Honor, I have identified exactly what I intend to use, and the state should be well aware of all of that evidence since it came from them. So they should have already examined it. They should already know what is potential impeachment material. Just like they don't tell me exactly what they're going to use. They just tell me which exhibits they have.
And that's a sign from the judge. You made a good
Simply
point.
because something's provided in discovery doesn't make it admissible, nor does it mean the state's committed it to memory, nor does it mean it constitutes valid impeachment material. So
I understand that, Your Honor, but I don't know what I'm going to use until I'm finished my questioning, Your Honor.
Okay, well, let's start with the first part. I mean, again, if I have to sit here and watch the whole thing, so be it. But we're not going to have a situation where these jurors are made to wait
Okay.
because
I have no problem with that, Your Honor. I have absolutely no problem with that. I have a flash drive that was part of the problem, is just the interface with the technology. I can't exactly plug my laptop in there. I found that out on Friday. Okay, so now that part I have no problem with. I also have no problem with using any of this impeachment material and definitely saying how I'm using it while I'm in the process of questioning the witness. I assume that is customary usually.
no,
right?
this is completely not customary.
No, I mean, it's customary to ask a question if she makes a misstatement, or if she, for lack of a better word, lies, then that's when I bring out a tape.
Okay, well, again,
But I don't have to do that.
again, I got to. What else are we going to do other than to see the thing? And so that's what we're here for. So let's.
I mean, if you would like an example, I could give you one.
No, I don't want a kind of sort of maybe. I want to see this and make rulings.
Now, this is a fine example of exactly what happens when you have an individual representing themselves. The judge is running all over him. He's 100% correct. He's provided the tape. They know what's on it. Unfortunately, it's going to be an individualized situation. That's what would happen if attorneys were in the room. They'd provide the portion of the tape. I guess the judge maybe wants portions, but as he said, hey, I've provided you with these tapes that I believe has potential impeachable material. Yes, Judge, you're going to have to watch it. So you're familiar with it. It seems like the issue here is the judge hasn't prepared for trial, or didn't expect to have to prepare for trial, because he didn't expect to have a pro se defendant raising issues like this. The state is playing games. They're the ones playing games here. Let's be clear on this. They don't want the impeachment material in. They don't want the IA interviews in. They don't want the victim to testify in this case, what she saw, what actually happened. It's why they offered this man a 2-year time served to kick this thing down. But the problem is, if he takes the 2 years time served, guess what happens? He loses the right to file lawsuits to hold them accountable. Key West, state of Florida, Key West officials in the state of Florida aren't held accountable. So it's not just as simple as, hey, take 2 years and go away. He's lost 6 years of his life to this process here, which is why he's standing in this courtroom fighting on his own. Now, the unique thing is because he's not a lawyer, it frustrates them, because he's clearly getting some assistance from people who know what they're doing. As a result, he's been able to essentially create the situation where these guys are having to go on record much more than they want to. He's forcing things to happen that otherwise the judge, isn't getting away with just saying, well, this is what we want to do. This is how it is. He kind of has some knowledge. Now, the thing that he doesn't have the ability to do, we're going to see this, and you're seeing it here, is what an attorney would normally do is have case law. So they could say, in this case, we did this, judge. In this case, that's what will move the judge. Unfortunately, it doesn't appear he has the case law, or he has cases just that he can cite right off of his head. But a good attorney is going to have cases he could cite to say, this is the issue right here, your judge. You can't do this. In this case, a judge allowed this. In this case, the Supreme Court said this had to happen. And because he's not an attorney, he doesn't have those things necessarily at the ready. So, this is where we're at. But let's continue watching as this gets much more interesting.
Because otherwise, I don't see where we've made 1 inch of progress from Friday afternoon.
If I may,
Yes, sir.
while I am not an attorney, and we've all made that clear, the thing is okay, the state is not going to tell me anything of any of the evidence that they plan on bringing in until they bring it in, right? They're not. They give it to me the same way. They give it to me in bulk, and I have to go through it and decide what I think they're going to use. Well, I imagine they're the same way.
No, sir. Have you ever seen a prosecutor in 27 plus years of doing this that doesn't have a very clear idea and presents it clearly? Yeah, sometimes there might be some little snippet or something, but not where there's apparently hours of tapes that they are using, frankly, very inartfully.
Okay, I'll tell you exactly one that I plan on using, and it's the hours-long tapes that they're talking about. There's 2 of them, the interview room tapes. Those I'm using to impeach the fact that she said specifically that I wasn't named a suspect till the 22nd, and I was named a suspect because of the testimony of John Travis Johnson and Rory Wilson. Those 2 hours worth of tapes, that's all they're discussing is me being a suspect.
We're not going to have that. I mean, you can show me, but we're not going to have 2 hours worth of tapes that somehow or other impeaches a minor point. So
no, and I would actually fast forward. I do have the timestamps. I can fast forward to each.
That's not what he's saying he's going to do, but see, he's not familiar enough, I think, with how to argue to the judge necessarily, or picking up on what the judge is trying to do here. These guys are, again, the judge is running over him, or trying to run over him, because what the judge is trying to do is say, oh, you're going to play this long tape. No, of course he's not going to play the long tape. He handed him a long tape where inside there, as any attorney would have to do, and again, if these prosecutors are aware of what's on the tape, they're going to know there's stuff in this tape, what the tape is. They've got to be aware of it. The judge has to be aware of it. There has to be an overall ruling of admissibility of whether or not this tape can be used, or if there's certain portions that they shouldn't have, which the state should have raised at the beginning of this, or I'm not sure where in discovery all of this occurred, but in terms of discussing this tape. But the bottom line is he's not intending to use 2 hours of the tape. He's going to take an excerpt of the tape and say, here it is right here. And if there needs to be 2 or 3 areas, if that doesn't move the witness to say, yeah, I'm lying, but that's going to show the jury that yes, they did consider him a suspect, and he's going to play that. But he doesn't have to show necessarily what portion he's going to use, because he won't know that until he asks the question. Now, I guess what he could also do is say, I intend to ask this question and impeach with this information if she says this. But because he's not an attorney, this is what they run into, because this wasn't something raised, and the judge isn't necessarily specifically being specific enough with what he wants, but that's what would normally happen, I guess, in this situation, where they would say, hey, what questions do you intend to ask? And he should already have his questions laid out, and these are the excerpts I would intend to use. But again, the judge wasn't expecting him to be able to argue the way he has, wasn't expecting him to be able to respond competently, and they expected they'd run him right out of the courtroom. It's not happening. So it's frustrating.
Each section that applies to that witness.
Okay, well, let's do it then.
Well, Your Honor, if I might, I'm definitely willing to do that. I'd still like to address the other issue.
I'm not going to address it. I will address it when I'm ready to address it.
No, I was just-
This is
asking.
this session. Mr. Tucker, you're starting to stray from the basic parameters here. I set this session for this issue, and that's what I'm going to deal with. And if Ms. Belmonte is unable to, we will deal with it, but if she's unable to testify, then we have these deposition to preserve testimony. But one way or the other, I will deal with this once I deal with the issue that I've set.
Okay,
So
I'll tell you what, I'll just play the tapes.
I mean, it is kind of an exigent circumstance here, and this is where it would be helpful for case law for him to say, hey, in this case, Judge, this had to happen here because what's going to move this judge is the threat of getting reversed. So what he needs to do here is, and whoever's helping him, if there isn't lawyers out here helping him, they need to start helping him anticipate what the judge is going to do here. So he's got a few cases to throw out and say, hey, in this case, Judge, in this case, Judge, in this case, Judge, this is what happened. This is what happened in the state of Florida. This is what happened in other areas, because that's what you would use if you would be challenging this in an appellate court. So it looks like we're going to get to watch, or they're going to start watching the tape here. We'll see how this goes. You can see the prosecutors over there are chuckling as they are attempting to cause as much issues for him and keep him on his toes as they can, as they try to keep out exculpatory evidence to his innocence. All right, let's move along here.
let's see if he's here.
Definitely do this for now. Yes, it is ours.
So I don't, no, I don't operate that equipment. You're saying that you need the assistance of Terry? Is that what you're saying?
Actually, I would ask for it only because I don't want to mess with her.
Let's see if he's here.
I just don't want to take a chance on her.
Is she available?
Yes.
Thank you.
It's amazing the amount of technology issues this court has. You would think that they would have, made sure that everybody's equipment worked. You would think the court would already have on record all of this stuff and convert it into a form that would be able to be played.
Matter to me. I mean,
It just seems I don't.
said I would. I mean, there's cannot imagine that there isn't some specific portions of a couple hours that can't be honed in on. But be that as it may.
Well, Judge, why don't you say it a different way? Ask him, what questions are you intending to ask, and what portions do you intend to impeach with those questions that you can lay out, and give him about an hour to come up with it.
That's one thing, but a
Quit being
discussion
vague.
between various parties is not impeachment, sir.
The statement that you did not know that I was a suspect until the 22nd. You had a
Well, sir, you can claim it is, and I make the decisions, and it might be admissible in some form and not the other, but you think you're going to, anyway, play it, but yeah, good, I hope so. No, sir, you don't need to placate me. Just do the business. I'm tired of all the extra fluff. Do what you claim you're going to do, otherwise you're not going to be able to. So.
Wow.
Which you should have had arranged. Again, if an attorney did this, it wouldn't even be close that I wouldn't have put up with it. I'm bending over backwards to try to facilitate you who doesn't really know what you're doing, and that's not a surprise, but you have the right to represent yourself, but you don't have a right to delay things or to attempt to, you can attempt to, but to admit things that aren't admissible. So in any event, this gentleman now needs one more time some assistance in operating the equipment. So could you give him a hand, please?
Well, Judge, I mean, you should have anticipated this. What'd you think? He was just going to come in? I mean, come on. And I've seen attorneys have plenty of problems with issues in the courtroom with technology. Wow. But the good news is he says this on record, so at least it's present. But
I'm sorry, I can't. Could you pause? What was it?
Here in charge of internal affairs, 2019-42.
No, apparently the court reporter has a question.
This one is audio only. Actually, the other ones are video, but it's only audio. Blank was it interrogation? So yes, they're all audio. Be specific.
This interview is being conducted at the Monroe County Sheriff's Office. It's the Sheriff's Conference Room, and it's taking place on May 8th, 2020 at approximately 1 p.m.
Good. Please tell me when you get to the part that you want to use, because all of this would not be. No, I don't.
In regards to what's commonly known as commonly known as the Treehouse murder, that took place on November 17th, 2017, and investigation regarding to the management handling of the investigation.
All that stuff is completely inadmissible.
well, no kidding, Judge. I mean, obviously.
Tyrone Tucker. Danielle, for identification purposes, please state your full name and spell it.
My name is Danielle, D-A-N-I-E-L-L-E, Malone, M-A-L-O-N-E.
Okay, and what is your present rank here? You're assigned.
I'm currently assigned dispatch as a communications officer.
Okay, and this interview is being recorded with your full knowledge.
Yes.
See, the judge is trying to throw him off his game a little bit there, I think, with these comments, which would normally shake somebody up, but he seems to be taking it pretty well. We'll see what he throws in here. I mean, you'd think they could just get somebody in the courtroom who would be able to operate the equipment. I mean, what is the problem with this?
That was much skinnier than
Who knows the equipment?
that we were looking for.
And of course, one call 911.
Yes.
Okay. So eventually, Franklin Tucker was identified as a suspect.
Yes.
How did that come? How did he get on the radar?
Well, his name first came up was that when we did the actual PCS thing.
He's got the sunglasses on. Jesus.
Lori. And then he was,
It is not.
That's all hearsay.
Well, I mean, I understand, but this is apparently the first part that he actually wants to use, where she said his name first came up with the Metro PCS stuff, and I could have swore she testified to it.
Exactly what she testified to.
She testified that I became a suspect because of Lori Wilson's testimony and Travis Johnson's testimony. I just went through it the other day.
Sir, she testified to that. That is not impeachment.
If I'm wrong, Your Honor, then I'm wrong.
It's not impeachment. That she said that.
Also, living with Lori. And then he got solidified as a suspect.
If you guys want to sit over here in the jury box or wherever.
Honestly, his interview and John Travis Johnson's interview.
His interview being Tucker.
Yeah, being Tucker.
How did that?
Well, some of the things like that he said that they all used, I believe they all used John Travis Johnson as they were with him going to buy cigarettes at some point during that night. So they linked them. All of them linked them.
This also brings up my point, Your Honor. I haven't asked some of these questions yet either. Right? So I don't know if I'm going to be able to use this yet or not. But now I'm playing it for the state. They could have, again, talked to the witness, whatever. But I mean, if they know what if they know what potential impeachment material I'm going to use or exact impeachment material.
And again, I'm familiar with this interview. I understand what you're saying. My specific question is,
So you are.
what is the inconsistency that he claims she said on the stand, and what portion is he going to use to rely on?
Can I say what her answers are going to be to my questions? No. So how do I tell you?
When we broke on Friday, Judge, we were right in the middle of, he was attempting to impeach her.
One question. That's it. Right? One. Not all. One.
Well, okay, in any event, you know.
I can keep playing it if you want. It's just, again, the witness isn't here. You can keep going if you want.
Themselves together, and they're trying to distance themselves from the crime.
Did the video, I know you mentioned video from the motorcycle place, or any other video establish the identities of your suspects?
Yes, the video from the Marine place. I don't feel like me. I don't remember what the name of it is, but it's right next door to.
Cosby's Marine.
Okay, yeah, that'd be it.
Yeah.
It's right next door to the Treehouse. When we finally got access to that, we could see on the video a dark colored truck circle the Treehouse. Then there's a break, and then the dark colored truck comes back, parks almost right in front of Cosby's, whatever, the Marine place, and you would see two people walking away from the truck, and based on the way the one subject was walking and everything about him is built because of how big he was, that was going to be Detroit. And then the other one, his body type and everything matched Franklin Tyrone Tucker.
I'm sorry, we can't speak over one another. I'm asking where's the impeachment, if that's supposed to be impeachment.
Everything that he told us.
This is an hour long, maybe an hour long. Hold on. I can tell you in a second. This is how long tape. She actually has asked about this more than once. And okay, just in this one alone, she says, yes, this verifies it, as this tape verifies this, which we established at length on Friday. No, it doesn't.
And she said as much. She said.
She did eventually.
We stopped the tape right where she says, Travis Johnson, what we see in the video matches up with what Travis Johnson told him.
She readily acknowledged that she can't see faces. She puts things together. This is a piece of the puzzle, sir. So if you think, Mr. Tucker, once again, you are deteriorating into interrupting. She doesn't say she can now see the faces. She is putting the evidence together. So there's no impeachment there. Yes, sir.
I don't mean to interrupt.
Well, you do constantly. But we take our turns, and you don't seem to get that. We talk one at a time because it's polite, it's the way to communicate, and it's the way the court reporter can get the information in the record. So in any event.
I'm very sorry.
Okay, sir.
But it doesn't feel like you're listening to me.
Oh, I'm listening very much. It doesn't feel like you're listening to me, but be that as it may, that ain't impeachment.
No, so far it is not. You're correct, Your Honor. But I also said there is additional in this statement. No, it's not the only time they bring this up.
Well, okay, let's hear it, because I'm trying to avoid the jury being, delayed.
I understand.
And to the video, that he was the getaway driver, that he took off because he got freaked out.
Okay,
And all of that matched up, so.
okay. Was there any other video? I know there's mention in the reports here somewhere, some video talked about.
There's a video of the outside of Tom Thumb. It's not actually Tom Thumb's video.
Oh, okay.
Tom Thumb, we attempted to get the video. They gave us video as the wrong day, and then we just never could. Every time we tried to get video from him, it just didn't work out.
Did, say the night of the incident, I know things go crazy. There's no doubt about that, but do you know if any detective, any road patrol deputy did go to Tom Thumb to see if they could roll back their video?
Me personally, I don't know if anybody did.
Okay.
I'm sure they did, but I don't know if anybody did.
Okay. Now, there was another video of two subjects walking towards what's called the warehouse where they live. It's at the corner of 3rd and 4th, I believe. Yeah, 4th and 3rd. By Tony's roof, that area.
Yeah.
That intersection. Did you see any of that video?
Yes.
Okay, what did you see on that?
Just two subjects walking, I believe there was two, they were walking towards what would be Tom Thumb and or the Treehouse.
Your Honor, to clarify, there are sections in here that, again, I haven't asked questions for yet. I don't know if she's going to lie about it. I don't know if she's going to tell the truth. So I don't know whether or not I'm going to use them. There is another section here at 2022 that I'm going to fast forward to because that section will be relevant to
Unfortunately, Judge, I think you're going to have to take this question by question. And I think he's realizing that.
I believe the night of the search warrant, John Travis Johnson wasn't on our radar yet. We didn't have the video showing the getaway driver. And nobody at the scene had mentioned John Travis Johnson yet.
Okay.
Because we didn't know there was a third guy.
Oh.
So John wasn't on our radar whatsoever. Franklin Tyrone Tucker was that night. Rolling went to jail.
Okay.
We eventually get the video showing that there was a getaway driver. And
video showing that there's a getaway driver. That is not a video showing there's a getaway driver.
The video shows a truck pull up, drop people off and leave.
I-
That is what she's referring to. You agree?
I'm sorry, Mr. Tucker. Once again, you're stepping on somebody when they're speaking. That's not how we do it. So, okay, so don't do it. Go ahead, Mr.
This is referring to a getaway driver. She's clearly, and she's articulate, she's referring referring to the videotapes where it shows the truck pull up, drop people off, and leave. That's what she's referring to as. I don't see an inconsistency in this video and what she's saying.
If I may.
Yes, sir.
The reason I did step on Mr. Mansfield's toes is because he agreed with me yesterday that we both conceded. You cannot see the truck leave. He just said the truck leaves. No, you cannot see that.
Sustain the objection. It's a plausible explanation and interpretation. It's not impeachment.
Your Honor,
Yes, sir.
Your Honor, you don't see the truck leave. You don't see a getaway driver sitting there. You cannot say that there's a getaway driver in the vehicle if you can't see it leave or you can't see somebody sitting there.
Objection sustained. Let's go on to the next.
I'll go ahead and take this tape out then. Or turn this one off. Because the other ones, like I said, I have questions that I want to ask before I use them.
Okay. Well, I guess we'll just, I don't know what else to do other than but please be ready to do so in a, timely manner as opposed to making the jurors wait, because I'm not going to have that again.
Okay, Your Honor, I apologize. I'm trying to be as clear and trying to be as specific as possible. I haven't asked the questions yet, so there's no way for me to know if she's going to lie or not.
Well, in any event, whatever, there's still a requirement that we move in a particular appropriate manner and not make jurors wait inappropriately. So I don't know how much more specific I can be, and in any event, I'll just leave it.
And I've heard you, and I'm trying to be as I'm trying to accommodate the court anyway. Yeah.
Well, we'll see. We'll see how it plays out, because so far your notion of what impeachment is a far cry from what it legally is. So in any event, so now we've got this, well,
Back to exhibits, and I apologize for it. Mr. Tucker, I did file a supplemental discovery on the 12th. I found out about it speaking, so I was checking, because I filed a motion to exclude these items. There's 7 items listed. It's a true homestead video from this Paul Belmonte, an IA report, investigation report and exhibits by Mr. Colonel Chad Scabilia, the Lumberton County Sheriff's Office, a letter of recommendation. And it goes on to list any and all Lumberton County Sheriff's Office Division of Internal Affairs documentary recordings, any and all Lumberton County Sheriff's Division of Internal Affairs documentary recordings mentioned in any depositions, any and all criminal, civil records from civil lawsuits resulting from this case related to any witnesses or parties. States the opinion that under the Florida Evidence Code, they are not relevant, they should not be heard or brought before the court of magistrate.
okay, so let me start again. I think I've got I think I've got it up to you. I'm just trying to set the stage here that the state received supplemental discovery on January 12th, and so you're not even saying it's a discovery violation, you're just saying that it's inadmissible?
I'm saying it's inadmissible, Judge. I mean, I would just, I guess for keeping things simple, I'm not going to claim a discovery violation, but these are all obviously not related to the facts as pertaining to this case. There are collateral matters of a civil nature. The state's opinion that under the evidence code, they are not admissible.
Okay, so now, defense. Go ahead.
I was just asking. Your Honor, I did look at the evidence code, and I did, I have looked at this. I can't remember maybe things I made mistakes in their summaries. As far as the ones where it is, all discovery materials, all that was left in from my previous attorneys. So that was actually, that's been in there the entire time. And bringing it to the court's attention now. Now that was, again, from that. And I also would imagine, yes, depending on what happens during the course of this trial, any of that can be brought. But whether or not it's admissible depends on the circumstances. I would correct that. That's what I would imagine. It's just like we're did look at, I did go ahead and look at the evidence code, and there were a few things in there, but yes, the documents from the IA reports, those are reports that are standard reports from the police department, and it is in the evidence code that those would be admissible.
Anything further from the state? Well, you know, it's awfully difficult for me to just, with one broad brushstroke, just eliminate all that. I don't know. It seems unlikely, but maybe there's some nugget in there that, you know, could be admissible. It's really hard for me to say right now.
Judge, I think we understand where your court's coming from. Our concern is this. I think we've already established Mr. Tucker's confusion that he's not going to play an hour IA interview and the jury's not going to hear it. This is IA investigator, blah, blah, blah. And I mean, that's an hour of hearsay is what that is. And irrelevance, other than if there's an inconsistent statement made on the stand and there's a specific portion that addresses that inconsistent statement, I would concede that might be admissible. But then as we just heard, what Mr. Tucker is perceiving to be impeachment is not. And that's my concern is that, you know, before the jury hears or sees anything, I want to know what he's complaining because I don't think there's impeachment in there. It's certainly not so far. And before that's done, I'd like to hear what he's going to play to the jury before that attempt to impeachment is done.
I mean, of course you're going to get to hear it. I mean, that's the way this should be handled. When there's a moment of impeachment, take the jury out for a moment, play it.
But I didn't plan on playing the entire tape. I gave you the entire tape so that you could look at it and see what I may or may not use. Just
The
like
judge is preposterous to suggest that a truck somehow phantomly drives itself. If a truck pulls up,
We don't need to, I already made a ruling on that one, okay? All I'm saying is that proper procedure is for the proponent of the evidence to have it honed in to what they believe is admissible in impeachment, and to not just keep a jury waiting for an inordinate amount of time while we do something that we should have done before. As far as these materials that were listed as supplemental materials, again, I'm not going to just make a blanket ruling, but to the extent that if there is something that Mr. Tucker believes is admissible before it's offered, we should alert the state and the court, and we'll have to have a hearing outside the presence of the jury to determine whether it is admissible. So that's the court's ruling as to that. Okay, so now have you seen the defendant's motion about emergency motion for immediate appearance? Had you seen that? Okay, so did you want to be heard on that?
Yes, sir.
Go ahead.
As I told you, and I gave my solutions in the motion, but Paula has taken a turn for the worse. It's not expected that she can make it as long as to get to the defense side of things. I did consult with my advisors. They said that it's not uncommon for a witness to go out of order, but that I should alert the court of the circumstances. And yes, Your Honor, I was attempting to get the primary care physician's recommendation for you and his contact information to verify yourself.
Okay, so you haven't come up with anything in writing then?
I do have a handwritten note by Ms. Belmont as to her wishes. The primary care physician, that's why I was late this morning, contacted the court to let them know. But yes, the primary care physician, as far as I know at this point, was writing the letter when I was on my way over here.
All right, so if I understand correctly, that even though we don't have the information documented that she is, to quote the motion, her health is at a critical point, and she well, again, to quote the motion, could be eminently fatal. So I had agreed earlier that she could testify by Zoom at the defendant's case. Now they're asking that the evidence be taken out of order in the midst of the state's case. So that's...
And I would object to that, Judge. I want the court to be aware. She was posting all weekend, back and forth with Mr. Tucker. Either one was posting. There were pictures of them together. She was complimenting him, what a great job he's doing. She was laughing at the fact that I raised an issue about him staring at us during the presentation. She announced at one point in one of the postings, I don't know who posted it, one of them, that she was going to be released today. And she reposted she'd be released today, but she wasn't going to have one of our people sitting in the room with her, as I had made the request last week. So she seemed to be posting fine all weekend long, and then this morning we're told that she's on her, her dying breath. So until Your Honor is able to get more information, I would object it. I mean, we're in the middle of a witness right now. And the state hasn't even rested its case yet. So I don't know. This is the reason her testimony was preserved, because we were told she was on her deathbed 6 years ago. So her testimony was preserved. I can't envision why we would somehow rush this testimony in the middle of our case and let the defense present a witness in the middle of the state's case and somehow tell the jury that's not part of the state's case, table that information for the defense case. I just think it would be highly improper and extremely confusing to this jury.
All right, defense?
Your Honor, first off, I am not aware of most of the postings that they're talking about because I haven't been paying attention to my Facebook. Yes, I did post a picture of Paula and I last night when I was in the hospital with her. And yes, they did inform me that in fact she alerted me in the morning to her condition. I went to the hospital, the nurse they verified that yes, her condition is in that state, but I could not, I'm not a doctor. I wanted to know from her doctor for Your Honor, right? Because I knew that was going to be something you would want to see. And yes, I was there this morning. He wasn't there yesterday. I was there this morning trying to get that, and he is now having authored that. Now the state may be mad about her posting whatever, but that doesn't tell you her health. It doesn't tell you that whether or not she's going to.
I'm not worried about her posts. I'm not. I mean, in terms of this issue, if it's some other issue, I'm not worried about the post as far as that's concerned.
If I may finish, Your Honor.
Yes, sir.
Again, I know we have to preserve testimony, so do they. Now, again, I looked at Marcy's law, and yes, she has the right to testify at any hearing. The victim's rights are clear. And all it says is that we have to make, every accommodation we can, or reasonable accommodation is what it says, right? Now, reasonable accommodation, I think it would be more than reasonable here, right? If she is that ill, and if the doctor says that, then why can't we?
Anything further? I'm hearing about Marcy's law now. I mean, it's kind of interesting because in 99% of the cases, the defendant would be not desirous of the witness, the alleged victim, being accommodated, quote unquote. In this case, is different, which is fine, but that's been brought up.
Judge, first of all, I'm not mad at anything. I want to clear that up. I'm just bringing to the court's attention information I have. I have a job to do, and I'm doing it. So I'm not mad about anything. She's not a state witness. She's not a good state witness. She's on our witness list. What she's going to testify to, we're already aware of it. It's in her preserved transcripts as well. But I don't think anything has been brought forward that would require this court to make those drastic accommodations at this point.
Anything else from the defense?
We've already admitted that it hasn't been brought forward yet, Your Honor, and yes, it is in the process.
All right. So here's what. I indicated that I would allow her to testify by Zoom from the hospital. I used my discretion. I could have said at that point no, but I felt that that was the fair, best thing to do. But at this particular point in time, I'm not going to force the state to, have a witness, adverse witness, called out of order when we have a deposition to preserve. My discretion at that particular point would be to say, if she's unable to testify by Zoom, then she can be heard when it's the defense's turn with the deposition to preserve. That's why it was done. I'm not going to force the state to have a witness taken out of order. Yes, yeah. Mm-hmm.
If, again, this is a myth, but if the doctor, if the primary care physician confirms what the defense is telling,
Yes.
and she is still wanting to testify, as is her right. Again, I mean, yes, we have, and to make it clear, in that motion, when we proposed her for that, we did the motion to perpetuate. It was on the condition that she would be unavailable, right? Unavailability, I've looked up in the law too. Unavailability means we have made every reasonable accommodation, and she cannot be here.
Yes, sir.
I'm just asking, would Your Honor change his opinion if he has the doctor's note in his hand?
No, I don't believe that the state should be compelled to allow or to have a witness taken out of order when there's another way that witness is able to testify during the defense's case when they want to call her by the deposition. So at that point in time, my discretion is that the utilization of the deposition to preserve. Yes, sir.
I'm not trying to be argumentative.
Well, you are, but maybe you don't think you're trying, but you are.
As the defense, the prosecution is well aware, and they argue themselves. There's a big difference between somebody giving live testimony and the video deposition. And I do think it's highly prejudicial to this case. It's highly prejudicial to the defendant. It is highly prejudicial to our case if that witness is allowed to, again, succumb to fatal injuries and not be allowed to testify. I also think it does go right against Marsh's law. She is allowed to testify at any hearing.
Yes, sir. I understand what you think, and I think otherwise. So that's why the deposition to perpetuate. I was told years ago, we need this, Judge. We've got to move. We've got to get this done. And lo and behold, now perhaps it's going to be necessary. I was willing to allow her to testify by Zoom. In your case, where I draw the line is to force your opponent to have their case interrupted by.
And this is where he needs case law to move the judge across that line.
Albeit by deposition to perpetuate.
Now, maybe there isn't case law, but he needed to research this, or someone on his team needs to research this issue, come back to the judge and say, case A, B, C, and D, this situation occurred.
But I was also informed by my advisors or my attorneys that this is not uncommon, that it is not uncommon to go out of order, that sometimes it's even done for things as
You need cases showing that. You've got to have cases. Judges are not going
It
to,
happens. It's
right,
true. It does happen.
show a case.
That doesn't mean, I understand what you can't see. I'm not going to force the state, oh, guys, you've got to stop right here. You've got to let Mr. Tucker present a star witness right in the middle of your case when we've got a deposition perpetuate. I don't think that's fair, and I think there's another way that you can get that testimony here. That's my decision, and, that's how I see it. So, unless there's something else, we have more materials to review, or
Judge, at this point in time, we have a motion coming in at noon. I guess the jury will be here at 1. Again, Mr. Tucker said that he's got other impeachment, but he doesn't know if he's going to use it or not. Again, the court's already made this clear that impeachment is a specific area. It's not a 2-hour tape. And I guess we'll have to wait and see what happens as the witness is testifying and see what Mr. Tucker's trying to use to impeach.
okay, I've done everything I can to try to make it as smooth as possible. We expect any other witnesses this afternoon, or?
Judge, that's the only one we figured by the time the cross is done and re-corrected, it's hard to have anybody else really here at that point, because we don't know timing. Maybe it would be prudent to have the court hear this IA interview that you keep referring to, Mr. Tucker.
That's not
Not the IA, the live mic tape or whatever that is.
It's 2 hours worth of tape.
Again,
Yeah, I can't
Well, then, pointless then, other than to expect the defense to be able to at least cue in on that part that they believe is impeachment. That's all I can ask, is that you have the, okay, so, okay, we'll see you at 1 o'clock, or maybe 12:55.
All right, guys. So that concludes the morning session. But couple takeaways here that I think we've got to be clear on here is, he's doing a decent job of coming in here and raising issues better than probably most laymen. But this is the stark difference when you have an attorney in the courtroom and you have somebody who is representing themselves, and that is the attorney can speak to the judge in a way that will potentially move the judge. And what moves the judge is case law, because case law says these are times judges either got reversed or these are times other judges were faced with this situation. And as a result, they moved in that direction. So he has to come back. And again, being the fact that he has advisors, that he has attorneys, I'm surprised he didn't come in and say, hey, here's a couple cases, unless this issue is so novel, although I don't think it is. It's so novel that it would never have been encountered or dealt with by a court. But my dad, it's one of the things he was known for, was always having a case at the ready, cases that prosecutors had never heard of or a judge had never heard of, or that was freshly decided. It was what he always did that separated him from the others. And that was to have cases ready, because that's what moves the judge, because the last thing a judge wants to do is get reversed. And that's kind of what the judge was telegraphing here, where he was saying, listen, I understand it's happened in other cases, but you're not telling me about those cases. You're not telling me about similar circumstances or anything about this case that says I need to let Paula Belmont testify in the middle of the state's case. One particular case that stands in mind was in the OJ case, when they had a witness come in, although they took her deposition outside of the range of the jury. They had her come in because she was saying she had to flee to Mexico or go to Mexico and was leaving. And the defense felt she had exculpatory information in regards to his alibi and seeing the Bronco at the house. And that was done. But that was, that's a case. So unfortunately, because they already have her deposition, but I think what he would have needed to do was make a showing to the judge that says, this is the reason, this is what she brings today that is outside of the range of the court, and then show case law that says, hey, this supports that. These are instances where the court has dealt with these issues. So he's not doing a terrible job. He's got the judge all fired up, which is good to see. He is doing things that attorneys wouldn't get away with, and that's what's ticking the judge off right now. And he seems to be, at least for the most part, following some sort of guidance that's outside the range of the court in terms of knowing what to say to the judge, or at least to let the judge know you're not going to just be able to shove this under the rug. But if he really wants to get this judge moving, he's got to come in with case law. He's got to try to do some research about these issues prior to going in, so that he can move the judge and get the judge to actually say, wait a minute, step back. How did you come up with that case, Mr. Tucker? Now, the question is, maybe he isn't. I mean, he seems very articulate. He seems very smart. He seems like he could handle that. But he's got, I can't imagine he doesn't have access to the various different search engines that would allow him to find cases, print those cases out, and provide them to the court. I assume he's in preparation of this, that he's dealt with stuff like that. So, but it's something that he needs to do and show up, and he could even have this revisited later this afternoon if he were to find some case law. Perhaps maybe his advisors will do that. And then, of course, the impeachment issue. The judge, once again, he needs to hone in on the fact that the judge said, listen, I'm not asking to play 2 hours of a tape. Of course not. I'm going to ask this set of questions that I have set up. And again, the judge isn't specifically saying what's your cross-examination? I don't know if he can do that or not. I'm not certain. I'm not familiar with that aspect of things. But essentially, obviously, he's going to say, I'm asking question A. If she answers in this way, I intend to play this excerpt. But at the same point, as you saw in the Charlie Adelson case, there were issues just like this, that the judge, in that case, it was bouncing in and out of the courtroom. And that's what the judge can do in this instance. He's going to have to take it on question by question based on if the witness is honest and testifies honestly. And that's the thing. And that's what he should have said is, listen, if the witness testifies honestly, judge, we won't have any of these interruptions. But if we're bouncing in and out of the court, that is going to be in and of itself going to show a big problem, because it's going to show that this witness, this police officer, is lying out her teeth. And that's what he's trying to do. Every interruption, he needs to make that clear to the jury. Every time he's saying is that, listen, he needs to be throwing that back to the judge. Listen, judge, whether you agree it's impeachment or not, I'm pointing out an instance where this witness is lying. And the issue isn't with me. The issue is with the witnesses. The issue is the fact that the state is putting on an individual who's lying. If the state wasn't putting on individuals that were lying, we wouldn't have this issue. We wouldn't have a need for impeachment. I wouldn't think there was a need for impeachment. I wouldn't have any issue to raise that as a layman, I don't quite understand how to raise it. I'm learning how to do it. But the issue being is these witnesses are lying. They've told lies. They've done things that are unethical. They've done things that are not inside the bounds of a competent investigation. And as a result, they're getting their feet held to fire the best way that a pro se attorney or a pro se defendant can do. But anyways, we will be back about 1 o'clock. That's in about 30 minutes. So we'll come back. We'll take a little break and we'll come back for the PM session. And we'll be back on record then live to cover that. So appreciate everybody that's tuned in, stepped in. Get this, share this case. This is an important case. This is one of the ones we want to watch, because this is a situation where there are some true issues going on down here. And it truly is, I think, going to become very clear to anyone watching this case that there is a strong likelihood that the state of Florida is actually comfortable putting a man they know to be innocent away for the rest of his life. And that is always uncomfortable. And that is always, always, always not okay. Anyways, guys, I will talk to you soon, talk to you in a few minutes. And until then, let you